Boy, we have a smorgasbord of information. I mean, we are covering it from A to Z today. 95 pages, and it's a lot of it is case precedent. Some dating back all the way to the 1700s. Very impressive array of court cases here. Combined and coupled with Bovier's Law Dictionary, Anderson's Law Dictionary, some law dictionaries I've never even heard of. This is stuff I remember where I got some of this material, actually. And it was clear back in like 2018, honestly. Anyway, we're going to get into citizen, sovereign, all that good stuff, court cases that explain it, and lay it out. Excuse me. And let's get started. A person is such not because he is human, but because rights and duties are ascribed to him. The person is the legal subject or substance of which the rights and duties are attributed, or are attributes. An individual human being considered as having such attributes is what lawyers call a natural person. Polk, First Book of Jurisprudence, 110, Gray Nature and Source of Law, Chapter 11, Black's Law Dictionary, 4th edition, page 1300. The terms citizen and citizenship are distinguished from resident or inhabitant. Jeff Cott versus Donovan, CCA, Arizona, 135 F period 2D, 213, 214, and from domicile, Wheeler versus Burgers, 263, Kentucky, 693, 93, S period W period 2D, 351, 354, First Carolina's Joint Stock Land Bank of Columbia versus New York Title and Mortgage Co., D period C period S period C period, comma, 59 F period 2D, 35 J.O., comma, 351. The words citizen and citizenship, however, usually include the idea of domicile Delaware, L period and W period, R period, Co period, versus Petrosky, CCANY, 250 F 554 557. Citizens, inhabitant, and resident are often synonymous. Jonesboro Trust Co. versus Nutt, 118 Arkansas, 168, 176, S period, W period, 322, 324, Edgewater Realty Co. versus Tennessee Coal, Iron and Railroad Co., D period, C period, MD period, 49, F period, SUPP period, 807, 809, and citizenship and domicile are often synonymous. Messick versus Southern PA, Busco, D period, C period, PA period, 59, F period, SUPP period, 799, 800, Black's Law Dictionary, 4th edition, page 310. Domicile and citizen are synonymous in federal courts. Early versus Hershey Transit Code, D period, C period, PA, 55, F period, SUPP period, 981, 982. Inhabitant, resident, and citizen are synonymous. Standard Stoker Co. versus Lower D period, C period, MD period, comma, 46, F period, 2D, 678, 683 period, Black's Law Dictionary, 4th edition, page 311. The Constitution emanated from the people and was not the act of the sovereign and independent states. The preamble contemplates that the body of electors composing the state, the terms people and citizens being synonymous. Negroes, whether free or slaves, were not included in the term people of the United States at the time. 2-1, they got asterisks by him. Asterisk 2, asterisk 1. McCulloch versus Maryland for wheat, 316, 1819. See also Chisholm versus Georgia, 2 Dallas, 419, 470, 1793. And Penhallow versus Doan, 3 Dallas 5493 1795, and Martin versus Hunter 1 Wheat 304, 324 1816, and Barron versus Baltimore 7 PET period 247 1833 asterisk 2, Scott versus Sanford 19 Howe 393 404 1857. City of Chicago versus Collins 51 NE 907 910. A license means leave to do something which the licensor could prevent. Blatz Brewing Co. versus Collins 160P period 2D 37 39 69 Cal period A period 2D 639. The object of a license is to confer a right or power which does not exist without it. City of Dayton versus DeBoss DeBrazi 23 NE period 2D 647 650 62 Ohio APP period 232. Thus, self-driving vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. Ex parte Hoffert 148 NW 20. Church of Scientology versus U.S. Department of Justice, 1979, 612, F period 2D, 417, 425. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings. Colonial Pipeline Co. versus Triangle, 421 U.S. 100, 1975. Statutes apply only to state-created creatures known as corporations, no matter whether creatures of statute and offices of state, local, or federal government. Cooper versus Aaron, 358 U.S. 1, 1958, 358 U.S. 18. No state legislator or executive or judicial officer can war against the Constitution without violating his solemn oath to support it. Court 1. The residence of a sovereign or similar dignitary. 21. A sovereign formal assembly or official advisor as a governing power. Webster's Dictionary. Court of Record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and proceedings according to the cause of the common law. Jones versus Jones, 188, MO, that's Missouri Black's Law Dictionary, 4th edition. Court of Record, a court having power to fine or imprison, or one having jurisdiction of civil cases over 40 shillings and proceeds according to the course of the common law. 37 ME 29A, judicial organization tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it and proceeds according to the course of the common law. Bovier's Law Dictionary, Black's Law Dictionary, 1st edition, Corpus Juris Secundum, at 1758, volume 20. The United States government is a foreign corporation with respect to the state. New York versus regarding Merriam, 36 N period E period 505 semicolon 141 N period Y period 479 affirmed 16 S period CT period 1073 semicolon 41 L period ED period 287. Crandall versus Nevada, 75 U.S., 6 Wall, 35, 46, 1867. It may be said that a tax of $1 for passing through the state cannot sensibly affect any function of the government or deprive a citizen of any valuable right. But if a state can tax a passenger of $1, it can tax him 1,000. Crime. An offense against sovereignty, an act committed or omitted in violation of the public law which forbids or commands it. Ballantyne's 3rd edition, 1969. Criminal action. An action by the sovereign, that is, the state or the United States, or instituted on behalf of the sovereign against one charged with the commission of a criminal act for the enforcement of the penalty or punishment prescribed by law. Ballantyne's 3rd edition. 16, Corpus Juris Secundum, Constitutional Law, Section 202, page 987, personal liberty or the rights to enjoyment of life and liberty is one of the fundamental or natural rights which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. Clearfield Trust Co. versus the United States, 318 U.S. 363, 1943, primary holding. A federal court can make a common law rule regarding federal negotiable instruments since they are controlled by federal law. Hence, common law in effect if the federal court proceeds properly. Identity theft. Bank versus Bank of Liverpool, 1896, 1QB7. But we do not think that he who accepted a forged signature of a payee deserves that preferred treatment. It is his neglect or error in accepting the forged signature which occasions the loss. See Bank of Commerce versus Union Bank, 3 New York, 230, 236. He should be allowed to shift that loss to the drawee only on a clear showing that the drawee's delay in notifying him of the forgery caused him damage. See Woodward Quasi-Contracts, 1913, subsection 25. Language example. This information was duly communicated to the other agent of the United States. Cohens versus Medal, 89 SE 876. Blair versus Broadwater, 93 SE 632 in 1917. The automobile is not inherently dangerous. Colgate versus Harvey, 296 U.S. 404, 56 S period CT period 252, 1935. The government of the United States and each state of the several states are distinct from one another. The rights of the citizens under one may be quite different from those which he has under the other. Connolly versus Union Sewer Pipe Co., 184 U.S. 540, 91 902. With regard particularly to the U.S. Constitution, it is elementary that the right secured or protected by the document cannot be overthrown or impaired by any state policy authority. Conley versus Union Sewer Pipe Co., 184 U.S. 540, 91 902, and La Ferrari versus Grand Trunk Rail Yard Company, 24 A period 848, 1892. O'Neill versus Providence Amusement Co., 103 A period 877. Cruden versus Neal, one of my favorite ones, 2 in period C period 338, 1796, 2 S period E period. There, every man is independent of all laws, except those prescribed by nature. He is not bound by any institution formed by his fellow men without his consent. Cruden versus Neal. Cumberland Telephone and Telegraph Co. versus Yiser, 141 Kentucky 15. Each citizen has the absolute right to choose for himself the mode of conveyance he desires, whether it be by wagon or carriage or horse or motor or electric car or by bicycle or astride of a horse, subject to the sole conditions that he will observe all those requirements that are known as the law of the road. Madden versus Kentucky, 309 U.S. 83, 84, L period ED period 590, 1940. Rights of national citizenship as distinct from the fundamental or natural rights inherent in a state citizenship. United States versus Cruikshank, 92 U.S. 542, 1875. It is quite clear then that there is a citizenship of the United States and a citizenship of the state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. Slaughterhouse Case 83 U.S. 16 Wall 36 21 L period ED period 394 1873. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the other, and each has citizens of its own. Davis versus Massachusetts, 167 U.S. 43, Partridge versus Batten, Supra. Moreover, a distinction must be observed between the regulations of any activity which may be engaged in as a matter of right and one carried on by government surfaceness of permission. Davis versus Wetzler. 263 U.S. 22 at 24, the assertion of the federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. De facto court, one established, organized, and exercising its judicial function under authority of a statute apparently valid, though such statute may be in fact unconstitutional and may be afterwards so adjudged, or a court established and acting under the authority of a de facto government, one BL judgment, subsection 173, in regards to Manning 139 U.S. 504 11S period CT period 624 35 L period ED period 264 Guildmeister versus Lindsay 212 Michigan 299 180 N period W period 633 635 Black's Law Dictionary 4th edition page 426. Dickey versus Davis, 85 SE 781, ex parte Dickey. Every citizen has an unalienable right to make use of the public highways of the state. Every citizen has full freedom to travel from place to place in the enjoyment of the life and liberty. People versus Nothus, 147 COLO period 210. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicle and personal property from either recreation or business, but by being subject only to local regulations, i.e. safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring a license, vehicle registration, or forced insurance. Dillon versus Dillon, 187 P27. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. Black's Law Dictionary, 6th edition. Due process clause. Two such clauses are found in the U.S. Constitution, one in the 5th Amendment pertaining to the federal government, the other in the 14th Amendment, which protects persons from state actions. There are two aspects: procedural, in which a person is guaranteed fair procedures, and substantive, which protects a person's property from unfair governmental interference or taking. Similar causes are in most states' constitutions. See due process of law. Due process of law, law in its regular course of administration through courts of justice. Due process of law in each particular case means such an exercise of the power of the government as the settled maximum of law permit and sanction, and under such safeguards for the protection of the individual right as those maxims prescribed for the class of cases to which the one in question belongs, a course of legal proceedings according to those rules and principles which have been established in our system of jurisprudence for the enforcement and the protection of private rights. To give such proceedings any validity, there must be a tribunal competent by its constitution, that is, by the law of its creation, to pass upon the subject matter of the suit. And if that involves merely a determination of the personal liability of the defendant, he must be brought within its jurisdiction by service of process within the state, or his voluntary appearance, penure, Pennier versus Neff, 95 U.S. 73 24 L period ED period 565. Due process of law implies the rights of a person affected thereby to be present before the tribunal which pronounces judgment upon the question of life, liberty, or property in its most comprehensive sense, to be heard by testimony or otherwise, and to have the right of controverting by proof every material fact which bears one question of right in the matter involved. If any question of the fact or liability be conclusively presumed against him, this is not due process of law. An orderly proceeding wherein a person is served with notice, actual or constructive, and has an opportunity to be heard and to enforce and protect his rights before a court having power to hear and determine the case. Kazaboski versus Kazaboski, 45 IIL 2D 405 259 N period E period 2D 282 290. Phrase means that no person shall be deprived of life, liberty, property, or any right granted him by statute unless matters involved first shall have been adjudicated against him upon trial conducted according to established rules regulating judicial proceedings, and it forbids condemnation without a hearing. Petit versus Penn, L.A. Appellate Court, 180, S.O. period 2D 6669. The concept of due process of law is, as it is embodied in the Fifth Amendment, demands that a law shall not be unreasonable, arbitrary, or capricious, and that the means selected shall have a reasonable and substantial relation to the object being sought. U.S.V. Smith, U.S. versus Smith, D.C. Iowa, 249 F period, SUPP period, 515, 516. Fundamental requisites of due process is the opportunity to be heard, to be aware of the matter is pending, to make an informed choice whether to acquiesce or consent, and to assert before the appropriate decision-making body the reason for such choice. Trinity Episcopal Court versus Romney, DCNY 387 F periods, SUPP period, 1044, 1084, aside from all else due process. Due process, 16C. The conduct of legal proceedings according to the established rule and principles for the protection and enforcement to private rights, including notice and the right to a fair hearing before a tribunal with the power to decide the case. Black's Law Dictionary, 5th edition. Draffin versus Massier, 92 S period E period 2D 3842. Persons may lawfully ride in automobiles as they may lawfully ride on bicycles. Doherty versus Ayer, Ayer, 83 N period E period 677 197 Massachusetts 241 and 246. Diet, D-Y-E-T-T versus Turner, 439 P2D 266 at 269 20 U2D 403, 1968, the non-ratification of the 14th Amendment by Judge A.H. Elliott, E-L-L-E-T-T, Elite, Utah Supreme Court. In other words, when the state martial law is imposed within the state to enforce national martial law, Congress has no reason to exercise its martial law powers. If a state has conformed to the new order, there is no need for Congress to intervene. And if citizens has not obtained the standing of a former slave by petitioning Congress for admittance to venue and jurisdiction of the 14th Amendment, i.e. statutory charter of person, then Congress has no power over the individual under this clause. Amendment 14, Section 5. The 14th Amendment is an extension of national military powers presently, presently used in a municipal charter and enforced by municipal laws stretched far beyond their original limitations and enforced in Article I tribunals, martial law. Elliott versus Lisi of Pearsall, P-I-E-R-S-O-L, 26 U.S. 328, 1828. But if it act without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a remedy sought in opposition to them. Even prior to a reversal, they constitute no justification, and all persons concerned in executing such judgment or sentences are considered in law as trespassers. The jurisdiction of any court exercising authority over a subject may be inquired into in every other court when the proceedings of the former are relied on and brought before the latter by a party claiming the benefit of such proceedings. Elk versus Wilkins, 112 U.S. 94, 101, 102, 1884 is a 14th Amendment case. The concept is true concerning all federal citizens. In other words, all federal citizens must be, by their very definition, a person who is completely subject to the jurisdiction of the federal government, such as citizens of Washington, D.C., Title 28, 3002, 15A, federal enclaves, and the territories, outer minor lying islands, Guam, Samoa, Puerto Rico, all that good shit. Virtually any legal concept stated by the courts concerning a 14th Amendment citizen is operative upon all federal citizens. The person declared to be a citizen are also persons born or naturalized in the United States and subject to the jurisdiction thereof. The evidence meaning of these last words is not merely subject in some respects or degree to the jurisdiction of the United States, but completely subject, all right? Which means they're fucking slaves. Remember, man didn't create government to be a fucking slave, all right? A slave to the thing they created. Emolument, noun, USU, PL, period. Any advantage, profit, or gain received as a result of one's employment or one's holding of office. Black's Law Dictionary, page 1586. Esquire, a man of English gentry, ranking next below a knight. A candidate for knighthood serving as an attendant to a knight, Webster's Dictionary. Excessive bail, 17C, bail that is unreasonably high considering the risk that the accused will not appear for trial, 8th Amendment, prohibits excessive bail. Black's Law Dictionary, 5th edition. This proves that the 5th edition was written after the Constitution was written and that the 4th edition would be more in tune of our founding fathers' intent. Federal Rules of Criminal Procedure, Rule 35, correction or reduction of sentence. A, correction. The court may correct an illegal sentence at any time. Additionally, the court may correct, reduce, or modify a sentence within the time and in manner provided herein for the reduction of sentence. B, reduction. A motion to reduce a sentence may be made, or the court may reduce a sentence without motion within 1 year after the sentence is imposed or probation is revoked, or within 1 year after receipt of the court of a mandate issued upon affirmance of the judgment or dismissal of the appeal, or within 1 year after entry of any order of judgment of the Wyoming Supreme Court denying review of or having the effect of upholding a judgment of conviction or probation revocation. The court shall determine the motion within a reasonable timeline. Changing a sentence from a sentence of incarceration to a grant of probation shall constitute a permissible reduction of sentence under this subdivision. The court may determine the motion with or without a hearing. FHA versus Burr, 309 U.S. 242, 1940, the Supreme Court held that that when Congress launches agencies into the commercial world and it endows it with authority to sue or be sued, that agency is normally just as amendable to suit as any private party. Sovereign immunity is waived. Florney versus First National Bank, Shreveport, 197 LA 1067 3 SO period 2D 244 248. This case has not been located. I'm guessing that it's a case that's not published. Somebody else went into the law library and dug it out of the fucking the trenches. All right, they put in some serious legwork. So I'm going to give it to you again because if you go into the law library, you might want to look for this. It's very important. It's spelled FLOURNOY versus First National Bank of Shreveport, SHREVEPORT. The numbers for this are 197 LA period 1067 comma 3 SO period 2D 244 comma 248. Okay. Now the reason I repeated that so slow is because some of our followers, viewers, and listeners and constituents go into law libraries all the time, and you know, if you butter up the librarian in there, you'd be amazed how intelligent those people in there are. They might be able to direct you directly to what you're looking for, and if not, they got nothing but time in the world to look at books. So if you find something interesting, they will do their damnedest to track it down, and they're amongst lawyers and judges all the time that are going in there. So be sure to write that down, all right? And a gentleman's asked me to put it in the chat. I'll put it in the chat later. For now, I got to keep rolling. A, code or statute is not a law, okay? And that's why that case is so important. And again, when cases are super, super important, they so often don't publish them. It doesn't mean that the case didn't happen. It doesn't mean that you can't find it. It means that it wasn't published and it's buried in the law library somewhere amongst thousands of fucking books, all right? But the law library, the librarian in the law library, those people, I'm telling you what, hardly anybody ever comes in there, strike up a chat with them, bring them a flower, bring them a coffee, bring them a fucking package of donuts, butter them up a little bit, be kind, be polite. They're not allowed to give you legal advice. Remember that. Don't be going in there asking a bunch of questions. They're going to give you this. Sir, I cannot give you legal advice. All right? I'm not here for legal advice, sister. I'm here to see if you've ever come across this, because I find this very interesting, you know, and see what comes of it. You know, you make frequent visits, you befriend these people, and naturally an equitable relationship builds. And, you know, from that, one day you might walk into the law library and she might go, "Psst, come here. I got this for you." You know, and she might dig it out for you. So that's really cool. It's FLOURNOY versus First National Bank of Shreveport, SHREVEPORT, comma, 197 LA period 1067, comma, 3 SO period 2D 244, comma, 248. Okay? A code or statute is not law. Florney versus National Bank of Shreveport, 3 SO 2D 244 LA, 1941. In the case of Norton versus Shelby County, 118 US 425 6 S period CT period 1121 1125 30 L period ED period 178 179 pages 186. The Supreme Court of the United States stated that an unconstitutional statute is no law, that it is always unconstitutional, and that the judgment of the court declaring it so is simply judicial recognition that the legislator had transcended the provisions of the Constitution. We quote from the language of the court. An unconstitutional act is not a law. It coffers no right. It imposes no duty. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. In the case of Chicago, Indianapolis, Louisville Rail Co. versus Hackett, 228 U.S. 559 33 S period CT period 581 584 57 L period ED period 966 at page 969, the same court, having declared a statute unconstitutional, said that act was therefore as inoperative as if it had never been passed, for an unconstitutional act is not law, and can neither confer a right or immunity nor operate to supersede any existing valid law. Page 1081. The general rule is well stated in volume 6, American Jurisprudence, Verbo, VERBO, Constitutional Law, section 148, page 827, as follows. The general rule is that the unconstitutional statute, though having form and name of law, is in reality no law, but is wholly void, and in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle just as it would be had the statute not been, as though the statute had not been passed, had not been enacted. Moreover, a construction of a statute which brings it in conflict with the Constitution will nullify it as effectually as it had in express terms been enacted in conflict therewith. Since an unconstitutional law is void, the general principles follow that it imposes no duty, coffers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no act performed under it. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it, because only the valid legislative intent becomes the law to be enforced by the court. A contract which rests on an unconstitutional statute is void and creates no obligation to be impaired by subsequent legislation. Under the heading of the Constitutional Law, 16 Corpus Juris Secundum, subsection 101, page 290, we find the following statement. Acts done under unconstitutional statutes as general rule, all acts done under unconstitutional law are, page 1082, void and of no effect, but acts that are merely incidental to an unconstitutional legislative enactment, it seems, may be valid. The legislator may direct payment of expenses incurred under an unconstitutional statute. Official acts. Although the rule that an unconstitutional law is nullity cannot be applied to work hardships and impose liability on a public officer who, in performance of his duty, has acted in good faith in reliance on the validity of a statute before any court has declared it invalid. In the absence of such circumstances, an unconstitutional law affords no protection to officers who act under it, and officers cannot be punished for refusing to obey such a statute. Judgment. Judgments and decrees rendered in the course of a judicial proceeding under unconstitutional statutes are, according to some authorities, void and should be reversed. By other authorities, a judgment in a civil action under an unconstitutional statute is not void, but merely voidable. And if such judgment becomes final before the statute is declared unconstitutional, it is valid and binding and cannot be disturbed, unless it is void or voidable for some other reason, at least where the court had jurisdiction of the parties and of the subject matter and had power to render the particular judgment, where, however, all the proceedings have not been completed before the statute purporting to give jurisdiction is held unconstitutional, and all the parties are before the court, relief from such proceedings under the statute should be granted. Page 1083. In Corpus Juris Secundum, Constitutional Law, Volume 16, subsection 101, at page 290, we find the following statement. As a general rule, all acts done under an unconstitutional law are void and of no effect, due to the fact that situations may arise resulting from transactions and acts performed under an unconstitutional statute whereby the parties involved are placed in a position where it would be most unequitable to follow the general rule that an unconstitutional statute was void ab initio and without any legal effect whatsoever, or where it was impossible for the court to undo what had transpired under an unconstitutional statute and to restore the parties to some reasonable position. The courts have recognized exceptions to the rule as a matter of public policy or necessity in such instances. In a case of Chillicothe County Drainage District versus Baxter State Bank et al., 308 U.S. 371 S 60 S period CT period 317 318 84 L period ED period 329, the United States Supreme Court said, the courts below have proceeded on the theory that that acts of Congress, having been found to be unconstitutional, was not a law, that it was inoperative, conferring no right and imposing no duty, and hence affording no basis for the challenged decree. Norton versus Shelby County, 118 U.S. 425 442 6 S period CT period 1121 1125 30 L period ED period 178 186 Chicago, I period L period R period Co versus Hackett, 228 U.S. 559, 556, 33, S period, CT period, 581, 584, 57, L period, ED period, 966, 969. It is quite clear, however, that such broad statements as to the effect of a determination, page 1084, of unconstitutionality must be taken with qualification. The actual existence of a statute prior to such determination is an operative fact and may have consequences which cannot justly be ignored. The past cannot always be erased by a new judicial declaration. The effect of the subsequent ruling as to invalidity may have to be considered in various aspects. With respect to particular relations, individual and corporate, and particular conduct, private and official, questions of rights claim to have become vested of status of prior determinations deemed to have finitely and acted upon accordingly of public policy in light of the nature both of the statute and of its previous application, demand examination. These questions are among the most difficult of those which have engaged the attention of the courts, state and federal, and it is manifested from numerous decisions that an all-inclusive statement of a principle of absolute retroactive invalidity cannot be justified. Counsel for the defendant state that this court has recognized an exception to the general rule and relies upon the case of Factors Traders Inc. Co. versus City of New Orleans, 25 LA period ANN period 454, and Barry et al. Versus Bass et al. 157 LA period 81 102 SO period 76. Foster versus Railroad Commission of State of California, 271 U.S. 583 46 S period CT period 605 70 L period ED period 1101 1926. It is not necessary to challenge the proposition that, as a general rule, the state having power to deny a privilege altogether may grant it upon such conditions as it sees fit to impose. But the power of the state in that respect is not, page 594, unlimited. And one of the limitations is that it may not impose conditions which require the relinquishment of constitutional rights. If the state may compel the surrender of one constitutional right as a condition of its favor, it may, in like manner, compel a surrender of all. It is inconceivable that guarantees embedded in the Constitution of the United States may thus be manipulated out of existence. Acts generally lawful may become unlawful when done to accomplish an unlawful end. United States versus Reading Co. 226 U.S. 324, 226 U.S. 357. And a constitutional power cannot be used by way of condition to attain an unconstitutional result. Western Union Telegraph Co. versus Kansas, 216 U.S. 1, and Pullman Co. versus Kansas, 216 U.S. 56, and Sue Remedy Co. versus Cope, 235 U.S. 197, 235 U.S. 203. The states cannot use their most characteristic power to reach unconstitutional results. Western Union Telegraph Co. versus Kansas, 216 U.S. 1, Pullman Co. versus Kansas, 216 U.S. 56, and Western Union Telegraph Co. versus Foster, 247 U.S. 105 and 247 U.S. 114. Gaines versus Buford, 31 Kentucky, 1 Dana, 481 501. The word sovereign state are Kabbalist words, not understood by the disciple of liberty, who has been instructed in our constitutional schools. It is our appropriate phrase when applied to an absolute despotism. The idea of sovereign power in the government of a republic is incompatible with the existence and foundation of civil liberty and the rights of property. Gardena versus Board of Registers of Jefferson County, 160, Alabama, 155, 48, SO period 788, 1909. There are then, under our Republican form of government, two classes of citizens, one of the United States and one of the state. Gestrin versus Pugh or Pug, P-U-G-H, 420 U.S. 103, 95 S period, CT period, 854, 43 LED, 1975. It is reasoned that our criminal law system holds persons accountable for past actions, not anticipated future actions. Justine versus Pug or Pugh, 420 U.S. 103, 95 S period, CT period, 854, 43 LED, 1975. Georgia versus Brailsford, Powell and Hopton, Hopton, 3 U.S., 3 Dallas, 1794. J. John. It may not be amiss here, gentlemen, to remind you of the good old rule that on questions of fact, it is the province of the jury. On questions of law, it is the province of the court to decide. But it must be observed that by the same law which recognizes this reasonable distribution of jurisdiction, you have nevertheless a right to take upon yourself to judge of both, and to determine the law as well as the fact in controversy. On this and on every other occasion, however, we have no doubt you will pay that respect which is due to the opinion of the court. For, as on the one hand it is presumed that juries are the best judges of the fact, it is, on the other hand, presumed that the court is the best judge of the law. But still, both objects are lawfully within your power of decision. Now that, I think, is wholly inadequate and bullshit, and here's why. Because, once again, man created government to protect the property of men, period, all right? And so when a jury of 12 says that something that the Congress or legislative body has done they don't agree with, then the jury rules at the end, all right? So they perverted it a little bit by saying, oh, yeah. The judge will decide the law and the jury will decide the facts. That's never how our judicial system was designed. Our judicial system was designed that if the manifest of some policy or provision was created and the community decided, you know what? We're not going to allow him to hang Derek over a fucking $87 motorcycle tax that seems absolutely fucking futile and frivolous. We're not going to allow him to, we're not going to allow the state government or the federal government to encroach upon our rights and violate Derek. Because if we allow Derek to be violated, well, then we agree ourselves to be violated. And how does that make any fucking sense? The problem is most juries don't think that way. You know, they get all amped up because the judge is like, I'll explain the law. Okay, you little peasants. You don't fucking have a clue of what the law is, all right? You understand me? It was like, oh, yes, master. Yes, master. I'm so glad you're sitting on that bench and you're going to tell me what the law is, boss. Oh, thank you, boss. Thank you, boss. I'm so glad to be a U.S. slave. Thank you so much, judge. Yes, sir, master. And then the prosecutor comes in proclaiming how he's going to explain to you how this man egregiously violated the law and why you all should be horribly upset about it. You should just be horribly upset because my imaginary friend the state, well, he's out $87. He didn't cup Derek's balls. He didn't wipe the sweat from his brow. He didn't pluck his nose hairs. He didn't pull hair out of his ass. But by God, I'm entitled to his fucking pocket with me and my crony buddies because, well, my imaginary friend says so. And the jury's so fucking gullible and stupid, they go, yeah, sounds about right. You know, the judge never lied to us. Judge is honorable. Judge is an honorable man. He worked really hard to get to that position. The judge is a fucking crook. So long as you'll allow him to get away with it, the judge is a fucking thief. He's a fox in the fucking henhouse with feathers and egg all over his fucking face. And he just loves the dumb jury. Loves it. Thank you so much for taking the time to be here. It's a great pleasure to have you here. This is the most important part of our judiciary and furthermore of the United States of America in this state. Your participation is greatly appreciated. And the prosecutor and myself, we just can't thank you enough for being stupid enough and dumb as fuck to agree with the bullshit that we allowed to be put upon your ears today. Thank you again for allowing me to control this matter and explain the law to you. And I just want to thank you once again for allowing my motherfucking asshole over here to fleece another great American patriot who was standing up for your rights, but you were just too fucking dumb to see it. And I just want to commend you guys. Thank you again. The jury is now, you are free to go. You are dismissed. Thank you again. This is a very important part of making sure that our judiciary runs properly. That's the kind of speech the jury got when it was all wrapped up. And I witnessed it and I was just like, oh my gosh, wow. Wow. And these people really believed it too. They were like, yeah, we all got to pay our taxes. Everybody's got to have a driver's license. Everybody's got to be a U.S. citizen. Yeah. Never once opening a book and ever understanding what the fuck they were agreeing to. Not fucking one jury member there understood a fucking thing about what that judge was doing. He was basically mocking them. Thank you, stupid fucking slaves, for cementing and reaffirming in fucking Custer County that you motherfuckers are nothing more than feeders and fucking breeders on our great land. Keep going out there and making this judiciary money. Thank you for your service. Now get the fuck out of here, you slaves, and go back to making us tax dollars. It's a fact. It's a fucking fact. All right. It is not only his the juror's right, but his duty to find the verdict according to his own best understanding, judgment, and consciousness, though in direct opposition of the direction of the court, John Adams. I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principle of its constitution. Well, in order to do that, the fucking populace has to be educated. So what do you got to do? You got to kick the legislator out of the education system, kick them, and instead of subjecting your offspring to a public fool system that is designed for you to obey and respect. Obey, respect. We're the authorities. You'll do what we say. That's why I dropped out of school at 13. I fucking know it's one of the reasons. One of the reasons was I couldn't stand a bunch of fucking ignorant fucking adults trying to lord over me when my own parents didn't have that much fucking authority over me. All right? I respected them, but I challenged them on every fucking aspect of things until I even broke my father's rules. And that's when my doors started getting screwed shut at night. The windows started getting screwed shut at night. Part of that's probably testosterone, ego, ignorance, young adolescence, wanting to scratch and sniff, all that great shit. But anyway, the point, still the same. Who are these people to lord over you? What a grand fucking illusion, and how far have we come from the actual principles of this great land? That one guy sitting in a black fucking robe, a cross-dressing fucking asshole, is over here convincing 12 of your fellow men and women who all sit at the bar and bitch about the government and yet don't realize the court system is the root to solving the problem. You will never be heard at the legislature. You will never be heard at Congress. You will never be heard anywhere but in that fucking courtroom where the jury has the right to decide and nullify the motherfucking law. Bam! Fuck you guys. You're not entitled to my pocket. You're not going to be stealing from my future offspring. You won't be stealing from my great grandbabies, and I'm going to fucking see to it that you're not going to do that. Now, with people like me in a jury box, because they do this jury selection thing, they feel us out. There was a gal in there who said, "Oh, I know all about jury nullification." Poof! That was the first one the prosecutor smoked. Don't want that girl in there. And she was young too, which was impressive to me. But because she said that, poof, she was picked out, gone. Don't want that one in there. That's a bad seed. She might plant some seeds and water it, and it might grow in the jury, and it might cause contempt for this court. We got to get rid of her, right? So think about that. I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its constitution. Thomas Jefferson. The friends and adversaries of the plan of the Constitutional Convention, if they agree on nothing else, concur at least in the value they set upon their trial by jury, or if there is any difference between them, it consists of this: the former regard it as a valuable safeguard to liberty, the latter represent it as the very palladium of free government. Alexander Hamilton. Glass versus Slope Bestie, 3 Dallas, U.S., 6, at 13, 1794. In Europe, the executive is almost synonymous with the sovereign power of the state and generally includes legislative and judicial authority. Such is the condition of power in that quarter of the world, where it is too commonly acquired by force or fraud or both, and seldom by compact. In America, however, the case is widely different. Our government is founded upon compact. Sovereignty was and is in the people. But if the people are fucking stupid, then you end up with what we kind of have now. The government is a direct reflection of the people, and the ignorance of the people has allowed for a despotic government to grow up in place and start to rule as though it's a dictator. Legislate all kinds of crazy cracker shit and say, it applies to you because 12 of your friends will definitely convict you because they don't understand what the fuck freedom is. They don't understand. They don't have a fucking clue because it's not taught in school. It's not taught in college. It's not taught anywhere. I'm starting to be of the mindset that you either have it or you don't. It's like common sense. no matter how many books you fucking read, you may never develop what is known as common sense, okay? And I know some people out there get 4.0 GPA fucking grade averages and literally will tell you at 60 mile an hour they can spit in the wind and it won't run down their fucking cheek. And I'm like, oh, fuck, jump on the back of the bike. I'll let you spit directly at the back of my fucking head. I guarantee you, although you got a 4.0 in school and you're considered a genius with an IQ of 150 plus, I guarantee you at 60 mile an hour, you will not hit one drop of saliva on my head. Oh, let's get on a bike. We'll see. You just don't understand physics. No, I understand physics really well. What you don't understand is just blatant fucking common sense. Common sense dictates that you don't have what it takes, lung capacity wise, to spit anything at 60 mile an hour and hit me in the back of the head with it. You just don't. So, anyway, common sense, book smart, and street smarts, some things some people will just never get. And we have to accept that. Goldsmith versus Cheney, 468 P2D 813, 1970, Wyoming. Venue in criminal cases, the problem whether an indictment against any accessory before the fact should be in the county of indictment or in that of the accomplished felony, along with that of the murder and felonies committed in several counties, was clarified in the English 2 and 3 of Edward the Ninth, C. 24, 1548 was the year it was decided. We inherited this common law and by statute specifically adopted it the background for interpretation of our laws. Goldsmith versus Cheney, 468 P. Period 2D 813, Wyoming, 1970. Generally, the interpretation of the state statute by the highest court of the state will be followed by the federal courts unless that interpretation is inconsistent with the fundamental principles of liberty and justice. Tyrell versus Krause, 422 F. Period 2D 852 853, 10th Circuit Court, 1970. Chavez versus Baker, 399 F. Period 2D 943, 10th Circuit, 1968. Cert denied, 394 U.S. 950 89 S. Period CT Period 1289 22 L. Period ED Period 22D 485 1969 and Percy versus Cox, 354 F. Period 2D 884 884 891 10th Circuit 1965 and cert denied sub nom. Charlton versus Cox, 384 U.S. 976 86 S. Period CT Period 1869 16 L. Period ED Period 2D 685 1966. The statutory construction given this statute by the Supreme Court of Wyoming does not offend the fundamental principles of the liberty and justice and appears to be a reasonable construction. The common law of England has been, by the statute adopted as a rule of decision in this state, subsection 817 W. Period S. Period 1957, and statutes are to be construed in harmony with existing law and their meaning determined in the light of the common law. Civic ASS-N of Wyoming versus Railroad Motor Fuels, Inc., 57 Wyoming, 213, 116, P. Period 2D 236, 245, 82, Corpus Juris Secundum Statutes, subsection 363, semicolon 3, Sutherland Statutory Construction, subsection 5301, 3ED. The crime of conspiracy, such as Goldsmith was convicted in Nevada, is an agreement between two or more persons to do an unlawful act. The crime is complete when the agreement has been made and an overt act performed to further the unlawful design. Jones versus United States, 251 F. Period 2D 288 293 10th Circuit Court, 1958. Cert denied, 356 U.S. 919 78 S. Period CT Period 703 2 L. Period ED Period 2D 715, 1958, and Martin versus United States 100 F. Period 2D 490 495 10th Circuit 1938. Cert denied, 306 U.S. 649 59 S. Period CT Period 590 83 L. Period ED Period 1048 1938. Accordingly, the statute is not so vague and indefinite that it offends the Due Process Clause, Nash versus the United States, 229 U.S. 373, 33, S period, CT period, 780, 57, L period, ED period, 1232, Miller versus Strahl, STRAHL, 239 U.S. 426, 36, S period, CT period, 147, 60, LED, 364, and it is not necessary that all of the parties be personally acquainted with each other. Neither is it requisite that one have direct contact with all others. It suffices if with knowledge that others have combined to violate the law, one knowingly cooperates in some affirmative manner to further the purpose of the conspiracy. Booth versus United States, 10th Circuit Court, 57, F period, 2D period, 192, Wilder versus United States, 10th Circuit Court, 100, F period, 2D, 177, decided November 28, 1938, and Allen versus United States, 7th Circuit, 4F period, 2D, 688. Government. When we come back, we're going to be talking about government. Republican government, one in which the power of sovereignty are vested in the people and are exercised by the people either directly or through representatives chosen by the people to whom those powers are specifically delegated. In regards to Dukin 139 U.S. 449 11 S period CT period 573 35 LED 219 Minor versus Harpaset 88 U.S. 21 Wall 162 22 L period ED period 627 Black's Law Dictionary 5th edition page 626. If you want to reference that and check it, it's right there in Black's Law 5th edition, page 626. Democracy. That form of government in which sovereign power resides in and is exercised by the whole body of the free citizens, directly or indirectly, through a system of representation as distinguished from a monarchy, aristocracy, or oligarchy. Black's Law Dictionary, 5th edition, page 388. We come back, we're going to be talking again about government. We're going to be talking about Hatfield versus London, 98 Wash, 516. And we'll be talking about sovereignty, ladies and gentlemen. Thanks so much for joining me. Thanks for all your support. Really appreciate it. And we'll talk to you real soon.